Good morning, everyone. Since it is 12 o'clock, we will start. Welcome to the first of 3 webinars. What I will do today is discuss estate planning. Next Wednesday, we will go into trusts, and then the next day is the next Thursday is Medicaid planning. But for today, we will do estate planning documents. If anyone has any questions, please feel free to use the question and answer. It could be done anonymously as well. And we'll start in a few minutes. Thank you. Okay, I think it's a full session, so we can start. My name is Asha Paulose. I started a virtual law firm in March of 14 of this year. And I do elder law and estate planning, and that encompasses a lot of different things that we'll go through today. First, let me just make sure I have this. Our goal, or my goal at the virtual law firm, is to assist people aging in place, protecting their assets, and to create that legacy, whether it's generational wealth or any other kind of legacy for their families. The services that I provide, they usually come in 3 phases. The first phase is completely up to the client. It's whatever makes them comfortable, whether it is that they turn 18 and they want to provide planning documents or execute planning documents for themselves so their family is, there's protection for them and their family, or when you get married or have children. But most of the time, my clients come to me when they are considering retirement, already retired, or a crisis occurs, or some illness occurs. Either way, it is whenever the client feels comfortable coming to me, and this is always the first step. The first step is creating the basic estate planning documents: power of attorney, last will and testament, and healthcare proxy. Sometimes when I go through it, I'll discuss doing a trust or Medicaid planning, depending how old you are. The second phase of how I help clients is through a crisis planning, or when someone is incapacitated. So I'll help handle Medicaid applications. If there is a disabled individual, I'll help them with supplemental needs trusts or planning, and then, if necessary, guardianship planning. And lastly, if a loved one has passed away, families come to me to assist them in opening up an estate, distributing out their assets, the way based on the wishes of the loved one. But for today, we're going to discuss the typical estate plan. And I know some of you are familiar with it, and some of you may not be. So we'll go through them individually and discuss it. The first is the last will and testament, the power of attorney, healthcare directives. Typically, it's the healthcare proxy, but there could be others. And then I do a deep dive of their financial accounts to ensure that their beneficiary designations are all in place as they want. Alternatively, if they decide, based on our strategy session, that they want to do a revocable trust or an irrevocable trust, we'll go through the pros and cons of each. We'll handle that also. If there's disabled individuals that they want to protect and they don't want their benefits being disrupted, we'll kind of go through the supplemental needs trust as well. And then there's those occasional clients, not saying most of you, but occasionally there'll be a client that wants to really get down in detail about their burial, their funeral, and things like that. And we will go through that as well. So for the last will and testament, I know most of you are familiar with it. It is a legal document, if properly executed, that can be filed with the court and lists the specific instructions of a person's wishes, how they want to distribute their assets after they pass away. The disclaimer is that it has to be a valid will, so it has to be executed properly. It has to be signed a certain way based on the laws of New York. Secondly, the property that we're discussing is a specific property that's under a person's estate. For example, if you have a 401k and you have a beneficiary listed on your 401k, that is not part of your estate or under the umbrella of what the will can control. So a lot of clients come to me shocked by this. They'll say, oh, but Asha, I put it in my will that both my children will receive evenly half, whatever I have. Great, that's great. But in reality, if you only list one person on your beneficiary, on your 401k, your life insurance, whatever the case may be, legally, that one child is the one that will receive all of it and not whatever is dictated in the will. So as we go through this, know that there are specific assets that will be under the will or under the direction of what the will can provide or can instruct. There are also things that only a will can do. For example, providing or nominating a guardian for your minor children. So if there's young families that come to me, I tell them that there's no really other way to do it. It has to be listed in the will if you want to specifically write a guardian for your minor children. Also, if you are a grandparent or someone that may have a minor children under your care in the future or have one now, not necessarily a parent, you can also have those instructions listed there just in case that is an option. When I see a young, almost retired parents, and they have a daughter or a son that's a single parent, I also include that in there so that, God forbid, anything happens to their child, their grandchild is also protected under their will. In the will itself, there's also language that I add in case any of your heirs, let's say your grandchildren or anybody, is under the age of 18 or minor, or if they're disabled, or if they are just unable to receive funds, or their portion of the estate because they have bankruptcy issues or they're going through legal issues that they can't just get their portion directly to them. So there's language in the trust that will state, hey, if there's any issues, that, or if the person government benefits will be disrupted, or they're under 18 and I kind of don't want to give them funds the minute they turn 18, there's language that could be placed in the will that their portion would go into a trust and it would be for only their benefit, but separately and not owned by that individual. Other times clients are very surprised, especially if you're in the retired age or older, which could be the majority of the people here today, that I want them to avoid probate as much as possible. And that's always a shock for people because they're like, oh, but I thought the will is so important, and I thought this is the only way to do it. But in reality, probate is something to avoid as you get older. It's not something you can do if you have minor children, but as you get older, it would be helpful based on the strategy session to kind of avoid this. And there's a lot of reasons why. It's costly, it's timely, especially for someone, if it's a spouse, they cannot gain access to those funds immediately. It is at minimum a 6-month process in most New York counties to receive the funds. And your exposure to debtors, Medicaid, other people that kind of get the first bite of the apple before the actual heirs do or distributees do, it's a high exposure to them. So we try to limit that as much as possible. For example, if you have a 401k or a pension plan, I recommend that you put a beneficiary in there. Someone that is, and you could put all of your 3 children in there. Perfect. That's great. Because that when you pass away, it will go directly to those individuals and not have to go through probate. Now, if it goes through probate and you owe, a certain amount, let's say $50,000 in medical bills, that there's a potential for the medical bill to get first bite of the apple before your heirs even receive any kind of funds. So the more direct funding you provide, the easier it'll be for your heirs. And that kind of multi-generational wealth is what we're trying to promote here. The second document in the estate planning documents is the power of attorney. After years of doing this, I believe that this is the most important document. It is something that can be a very powerful tool immediately for you, or only when you are incapacitated or unable to handle your finances. It is a document that's about 15 pages. It lists in excruciating detail all the powers an agent that you nominate or designate to handle your finances, whether it's to, change something in your life insurance policy that needs changing, or updating your bank information, or transferring, consolidating all of your bank accounts into one account, whatever you need them to do, selling a home, whatever that is, your agent under power of attorney can handle that for you. It is something that you would have to sign, 2 witnesses would have to sign, and the agent itself would sign. You can have more than one agent. I always recommend at least 2. And I recommend that these agents can act separately, but it is completely up to the client to decide how they want to do that. Some people may not want to trust one person to handle their finances, I understand, and they could assign 2 people to work jointly and handle it together. I prefer not to do that because they have to go into the bank account, like kind of hold hands and go into the bank account and do everything together. But if that's the kind of protection you need, great. This is an easy alternative to what is to a more costly and timely process, which is guardianship. So if you take an example like a 401k, and I know I mentioned this a lot today, but a 401k can only be owned by one person. So if you own that, gone are the days that your child or your spouse can just call the company and say, hey, I need this information, or I need to do this. Mom's in the hospital, I need to withdraw the funds to take care of her, in the hospital, or pay her bills, or pay her mortgage. They will not provide that kind of access to anybody. The only 2 individuals that financial institutions will give that access to legally is an agent under power of attorney or a legal guardian. An agent under power of attorney is through this power of attorney document, this 15-page takes about 20 minutes to sign document. A legal guardianship is something that it costs time and money, and it is involves so many individuals and court involvement just to get access to your 401k or anything else for that matter. So it is crucial that anybody with financial accounts have this power of attorney to assist them just in case they are unable to or incapacitated during their lifetime to have someone else access their accounts. But as I've been doing this for a couple of years, I see that the power of attorney can be much more than that. Like it doesn't have to be just for someone to pay your house bills and mortgage when you are sick in the hospital, in a coma, or incapacitated in some way. It can also be a useful tool to gain trust over somebody when it comes to handling finances. The truth of the matter is that, as everybody gets older, children kind of handle the finances a little more for their parents, or at least that's what people hope to do. And the easier it is for someone, the more the less complicated the process is, the more you can enjoy kind of handling other things like medical issues without worrying about the finances involved. When you go to the bank, you want a quick fix, and the bank wants to provide a quick fix for you. So they will say, okay, make one of your kids a joint account owner. Great. Now your kid is a joint account owner to your business, a checking account, and they can pay your bills for you. But, when clients come to me and state that they have done this, I get very frustrated because the bank is not looking out for your estate planning needs. They're not worried about the consequences of what that entails, because essentially what you're doing is, if you have, let's say, $40,000 in your checking account and you need a little help paying the bills, and you add your daughter to the joint account to create a joint account, you're essentially giving her a gift of $50,000. And when you do that, you're giving your daughter allowing her to have complete access to it, for her to do whatever she wants. And I know a lot of you say, oh, that, nothing will ever happen, but it's just less control on your part, which I prefer not to have my clients lose that control. So in a power of attorney, your daughter can be an agent under power of attorney, withdraw or deposit accounts in your bank account, but only with the caveat that they're doing it under your best interest. They don't have a stake in that claim. They can't withdraw money for their own. You're not giving them a substantial gift that could affect your Medicaid planning. And when you pass away, those funds go directly to your one daughter, and maybe you didn't want that to actually happen, and maybe you have other kids and you want to get distributed out accordingly. So this is just a more fair and ethical way to kind of allow your children to have access to your financial accounts to assist you, but without losing all that control to your children. This is only during your lifetime. It is something that could be helpful if you're overseas and they can kind of represent you here, and your agents would have to sign the document as well. So we can go through kind of some of the misconceptions about a power of attorney, because I know it is a lot to consider to have someone have control over your finances, and it is difficult for people to do that after working so hard on their own. There is a question about, let me read it out loud. How about if a parent makes the kids a beneficiary to the checking account rather than an account owner or a POA? So, we throw out these designations all the time, and it is difficult to, sometimes it gets confusing. But as a beneficiary, that is only when you pass away. So when you pass away, it's good to have a beneficiary listed in all of your accounts, but it should be a complete list. So if you have, for example, if you have 2 children, the recommendation is to put both of their names as beneficiaries. If you have 1 child as a beneficiary, they cannot access your account while you are living, pay your bills, or do what they need to do. But when you pass away, it would go directly to them. They wouldn't have to go through probate and a will and all that stuff. So that's the benefit of a beneficiary, but it can't assist you at this moment. To be an account owner, I discussed that, but there's this extra thing, which is an agent under power of attorney, which is someone that can go to the bank and say, hey, I am representing my mom. I need to withdraw this amount of money to pay the electric bill. And the bank can provide that, access to you. Okay, we'll keep going. These are misconceptions that a lot of clients come to me and ask, and I have to kind of correct them. None of these are actually true. So when it says a power of attorney grants the agent the right to do what they please with your estate, it's just not true. They themselves have to sign a page in the power of attorney, and they essentially become a fiduciary where they promise to only withdraw funds per the interest of the grantor, you. So they can't really, take out all your money and go on a trip around the world or whatever people do nowadays. They have to act on your best interest, and they sign, and it is notarized by somebody so that you're stating, I promise to do that. The second is a power of attorney survives after death. No, it doesn't. This is only for your use now, which, I can say is more important to me when I am living now. If I, God forbid, get into some kind of accident and I'm in the hospital for 3 months, I want to be able to say that my mortgage was still paid for, my business was still running, and, I had everything under control. My kids' tuition was still paid or whatever needs to be paid, and things were still running smoothly for those 3 months. And then afterwards, I can go back to my own life without being in an incredible amount of debt or owing people a lot of money, which is usually what happens in crisis situations where a lot of money is being exchanged. The third thing is once you sign, you give up the right. No, you don't give up any right to your financials. You still have control. It's just you're mirroring that control to another person. So I give the example of both of you and your agent walking into a bank. You can go to the ATM and just take out any money you need, but your agent can go to the teller and withdraw, money as well for your benefit. You have dual powers. You do not lose any control. There is only one kind of POA, and the next one is you can find a power of attorney on the internet. This is all true, but New York State, because we want to safeguard all this, New York State actually has a specific statutory power of attorney that is only used on the state that provides the powers based on all of the issues that attorneys have had for the last 10 years. It was a new power of attorney was created and put into effect of June of 2021, and it lists all the powers, and it's in a specific language that New York State approved or the legislature approved. Is there one kind of POA? When a client comes to me, I personally recommend that you give an agent the broadest authority, because you're essentially stating that you trust them and you want to provide them with this authority. But why limit it? Because especially during Medicaid planning, when I am asking agents to transfer funds so that their parents can be on Medicaid, it is so frustrating when the power of attorney is limited. And so sometimes parents will cross out, well, I don't want them to touch my life insurance policy, so they'll cross it out. And then the power of attorney becomes limited, and they may not be able to be eligible for for a Medicaid application. So there are different kinds of POAs out there, but for this particular situation, for estate planning, for long-term care planning, I recommend that it's the broadest sense. You can have one agent, you can have two agents, you can have two agents working together, you can have a successor agent, which means that only if the first agent is not possible, or they're sick, or they passed away, that the second agent kicks in. There's a lot of different ways you can do it, and during a strategy session, we discussed that. But at the end of the day, that's what I recommend, because I want it to work in your favor ultimately. Your power of attorney does not handle any of your medical decisions. It's just financial accounts. So it's typically used for retitling your home, consolidating your bank accounts, applying for Medicaid, signing a retainer for an attorney, things like that. That's where it would be useful. And lastly, you only can sign a POA when you're unable to make decisions. No. So this is where you have to have a little bit of foresight to know, okay, I'm going to need this in the future. I got to take care of it today, because once a person has some kind of incapacitation or some kind of disability where I might not know if they understand what they're signing, I can in good conscience have them sign a power of attorney. So if a client comes, if a child comes, usually the situation is that the child of the client comes to me and says, hey, my mom's really sick, she's in the hospital, can you sign a power of attorney so I can figure out what to do with the house? Great. I go to the hospital because she's my client, not this child. She's the client. And when I speak to her, she is either heavily medicated or, maybe third, fourth stages of dementia or Alzheimer's, or, just unable to understand what's happening generally. And, the attorney really has to make that assessment right then and there. And if I don't see it, man, I can't do it. I can't have her sign a power of attorney. And so their only other option is to go through that guardianship proceeding. And that is not what you want to hear when mom's in the hospital. You've got a house that you got to take care of, and you don't even live in this county. You live in Florida or something. So it is so crucial to have these documents in place to make that moment when a crisis occurs, like mom's in the hospital, what should we do? Where you have all your tools available to you at that moment, because typically you don't want to think about the finance part. You don't want to think about the legal part. You want to just be caring for mom. The last document that I usually try to include in the estate planning as the basic estate planning documents are healthcare directives. Typically, we just do the healthcare proxy, and we'll go through why. But healthcare proxy allows you to appoint one person and one person only as the agent to make medical decisions for you. It's a little bit different from a power of attorney, because power of attorney, you don't have to be incapacitated or unable to make decisions for them to start helping you. They can start helping you immediately. So if you just don't feel like getting your car inspected or dealing with insurance companies, you can have your agent do that. But with the healthcare proxy, if you want to appoint someone to make medical decisions for you, it can only be done when you are unable to. So they can't, while you're fully able to make medical decisions, the agent can't just go to the doctor and say, hey, I want to change the process or change the treatment. You yourself have the decision and the ability to do it, and you alone can do it. If you're unable to, if you're heavily medicated, if you're in a coma or in the last stages of dementia, those are the moments where an agent can come in and deal with the medical decisions. New York State has their own healthcare proxy statutory language, and in it, it says that only one person can do it. I think the intent is that they wanted to avoid any kind of bedside argument. So they themselves agreed that it would only be one person. Now, you could have as many people as you can, it would just be listed in an order. So I've had clients have like up to 7, 8 people listed. If not my mom, then my dad, then my brother, then my sister, so they'll list it down. Now, New York does have something called a Family Healthcare Decisions Act. It basically states that in an emergency situation, they have a specific order of who they're going to listen to first. And we can give the benefit of the wisdom of healthcare professionals to handle that at that moment. And I understand, even a friend can come in if there's nobody else and make the decision for you on your behalf in an emergency situation. But a healthcare proxy can be a little bit more helpful for you when it comes to as you get older, because there are situations when someone is heavily medicated and just unable to make those decisions, and it is on a daily basis that occurs. So you're going to a regular dental or doctor or any kind of appointment, and you are heavily medicated and just cannot make these decisions. It's nice to have somebody there. It's also nice as the disease progresses for someone with dementia or Alzheimer's to have somebody with them at these doctor's appointments. And to have this document so that you're kind of armed with this ability to ask the doctors any questions, to be there in the room, to listen, and to make some decisions for the person. There are additional documents, like I said before, that I consider when we're talking, in addition to trusts and any kind of supplemental needs or revocable or irrevocable trusts. Again, there are some clients that are very interested in dealing with their instructions and how they want to be treated if they're sick, and after they pass away, their burial and funeral instructions. So we will go through that if necessary. When it comes to DNRs and MOLST forms, I know people have heard of that, and clients will come to me and ask me for these forms, and I'll say to them that's something that you go through with a doctor for, and it's something that you have a conversation with your doctor and discuss. But the two things that I want you to consider before you speak to an attorney is a HIPAA form and a living will. HIPAA form is something that you have probably signed countless times when you've gone to the doctors or hospitals. It basically allows somebody to have your medical information, speak to the doctors, and deal with insurance companies. It is such a great option to have when all I could think about is a moment where dad was in the hospital and all the doctor said was to get the prescription. Well, did I know his insurance company? Did I know his prescription? Did I know what pharmacy he went to? None of that. So it's a good first step that you can give your child when you're trying to kind of, open up yourself to these scenarios. So if you sign a HIPAA to nominate agents to be able to receive medical records and talk to your doctors and deal with insurance companies, know that they cannot make any medical decisions for you. They can just be a breath of fresh air and help to you by calling in the insurance companies, dealing with the billing, whatever it is, because they have that HIPAA form in place. The next thing is the living will, and I know a lot of estate planning attorneys and elder law attorneys will include this in their services. And though I'm not a big fan of it, I think it is a good it's a good template for a discussion with your healthcare proxy agent. So a living will is basically like a written instruction. A lot of people call it the pulling the plug document. It's basically, what are you comfortable with and when do you want to kind of forego medical treatment at this time and just kind of have medication for the pain relievement and pain medication but not really to assist you in, you know, the feeding tube and things like that. So there are a lot of templates for living wills. What I recommend to clients is to speak to their healthcare proxy agent, the agent that they decided will make their medical decisions if they're not able to, and go through one of these templates with them and say, hey, this is what I'm feeling at this moment. But no, your wishes and your idea about things when it comes to medical treatment 10 years ago is completely different now. So post-COVID, pre-COVID, that is a vast difference. And to have something in writing that is legally bound is I get a little nervous about that because I think people's minds change. So a living will, I think, is a good template. It's a good reference guide, but it might not be the best option if you change your mind in the future. So consider that. I really like 5 wishes. I know I've gone through that with my family. 5 wishes goes into complete detail. And I know clients have said, oh, we did 1 page and we were done. And then other clients have said, I filled out every single thing. And if you Google 5 wishes, it's just a list of questions you could ask yourself how you want to be treated for end of care treatment. Okay, so I wanted to kind of go through a little bit of my process before we end today's session. Um, and if anybody has any additional questions, please let me know. I'm going to try to look at it. So the process I have is for dealing with estate planning documents, and other attorneys may have different processes. So I can go through kind of like the basic, which is you call a law firm, you have to set up an appointment, you come in. If your children can make it, they can also come with you, and you have a discussion and you decide whether you want to retain that attorney. And as for me, it's essentially the same thing, except it's all done online. You'll receive an email to schedule an appointment with me after you fill out the contact forms. And then we have that strategy session. The strategy session will go through all of your financial accounts. We'll go through, what you really want, what you want to happen to each of your assets, and, how the dynamics of your family is, so that we can figure out what the key issues are that may be an issue for you specifically. And then after that, I kind of summarized everything and put it into a letter. I'll go into expand on certain legal issues when it comes to recommendations, and then I'll list all the pricings for each thing. And then if you decide you want one or all of the recommendations, I give you an agreement. Let's say it's for an estate planning a package. I will send you all the drafts online, and then we can go through it line by line, every single document, the will, the power of attorney, so that it fits your needs. And once it's all settled, I'll come into the house and do a signing, or we can go to an office that, a local office that I have nearby where you live. I handle Long Island and Queens, all the 5 boroughs, Westchester, Rockland, and a couple of Hudson Valley counties. So I think it is a fantastic approach for someone who has children that may live out of state and want to include them in the process, or if they just are unable to travel. This may be a good approach also. It hasn't been less than 90 days. It hasn't been 90 days since I've started the business. So I'm grateful for everybody that's attended today and for all the support and advice that you've given me the last 90 days. My approach was to educate my clients and give back to the community that I grew up in, and also be completely accessible to the families or to the clients that I have. So I have evening scheduling and weekend scheduling, and this all kind of makes it easier for both me and for the clients to get what they need. If you have any questions, let me know. Everyone that has attended today will get a free strategy session. So whichever email that you have attended today, that will be on a list. And so when you sign up with that email, you won't be charged for that strategy session. So I urge you, even if you don't want to do estate planning documents, or you want to talk about anything, let's have that session. Let's discuss it. Why not? It's free. And we can go through everything. Next Wednesday is the trust, and we'll talk about what to do with your home, whether a revocable trust or an irrevocable trust or a life estate is necessary. And then lastly, we'll talk about Medicaid planning, what that entails, why someone with a high income would ever need Medicaid, and how it's necessary for most of my clients. It was a pleasure speaking to all of you. Please let me know if you have any questions. You could email me as well. Thank you.